Sujit, the CCF has filed a legal challenge to the federal government's use of the Emergencies Act. Why?
And so the Emergencies Act is an extraordinary piece of legislation because when it's triggered by the federal government, it effectively amounts as a temporary amendment to the Constitution, and in two big ways. The first is that it delegates vast lawmaking power to the federal cabinet that would normally have to be exercised by Parliament as a whole, and in this context, where there is now a Senate that operates at times quite independently of the House, a bicameral process. With committees and debate, and the federal cabinet can do things instantly without any of that process. So, for example, creating a crime and attaching penalties to it. And secondly, the act allows the federal cabinet to enact such law-like measures in areas of provincial jurisdiction. And so, without the Emergencies Act, the federal cabinet can't do either thing. And so it's really important that this extraordinary power be exercised very narrowly and very carefully within the tight confines built into the legislation itself.
Janani, sort of same question. What's your take on the importance of this case?
So this is the first time that this Emergencies Act has been used. And I think we as Canadians want to ensure that when Parliament invokes such an extraordinary piece of legislation, that they're doing it for the right reasons and they met the right requirements. So this is going to be a really important case for us to see what kind of guidance is going to be provided in future cases so that if this was a mistake, we'll learn from those mistakes.
So, Janani, I want to go over briefly some of the powers that the government gave itself under those emergency orders. What were they? What did they empower themselves to do specifically when they invoked the Emergencies Act?
So there's two sets of regulations that came about as a result of resorting to the Emergencies Act. So the first is emergencies regulation, and those powers have to do with public assembly. They've essentially made it so that you cannot go to a public assembly if it can be it could reasonably lead to a breach of the peace. And we'll come back to the question of what does that even mean? And the second set of regulations that they've invoked has to do with economic regulations. So they have to do with banks who have information about our bank accounts and requiring those banks to provide that information to the police or to financial institutions if they think that it's suspicious transactions in relation to those public assemblies.
Now, Sujit, the federal government said they needed these powers in order to deal with the protests, but we argue that that isn't true. They could have used ordinary police powers. So can you elaborate on that a little bit?
Right. So, the Emergencies Act sets out 4 different categories of emergencies, and the emergency that was declared by the federal cabinet is what's called a public order emergency. And one of the legal conditions for declaring a public order emergency is that the existing laws of Canada not be sufficient to deal with the problem. And so what we did in our pleading and what we intend to argue in court is that police authorities at the municipal level and also provincial police have extensive powers under the criminal code and provincial offenses legislation. And there are many offenses that were violated by protesters. And between
these were, sorry to interrupt, Sujit, these were things that were dealt with, for example, the Ambassador Bridge, using the ordinary powers. I want to follow up on this, but we've got to go to commercial break. We will be right back.